Hi guys, we are going to talk about a very important and useful law in New Zealand, which is Consumer Guarantees Act. Basically, there are 6 elements of the Act which are quite important for businesses to know. The first one is who the Consumer Guarantees Act applies to. The CGA applies to all business who sell products which are for personal, domestic, or household use or consumption, including small and second-hand businesses, pop-up shops, and regular trade meat sellers. People who hold one-off garage sales or one-off online sales that have no regular transactions do not need to follow CGA. Selling products in this situation includes selling goods and services. However, CGA doesn't apply if goods and services are resupplied in trade, or being used to repair goods and features online, or consumed in the course of production or manufacture. The second question is, what is the definition of a consumer? In a legal sense, the consumer is the people who have purchased goods or services that are usually used for personal, family, or daily purpose, and are not intended for resupply or reproduction.
What guarantees are given to consumers? The Consumer Guarantees Act provides consumers with specific minimal guarantees as to the quality, suitability, and other aspects of the goods or services, as well as the right to provide basic protection for their benefit. The guarantees for goods consist of it must be of acceptable quality, which means fit for all purposes for which the goods of that type are commonly supplied. If the consumer makes known the purpose for which acquired, then it must meet that purpose, unless it's not reliant on the supplier's skill or judgment. Acceptance in appearance and finish, it must be free from minor defects, it must be safe, and it must be durable. Goods must also comply with the description, repairs and spare parts must be provided if needed, and the manufacturer must honour the express guarantees. For services, on the other hand, it must be completed with reasonable care and skill, and must also be fit for its particular purpose. It must be completed within a time constraint, if no time guaranteed upon, within a reasonable time. The price must also be at a reasonable standard.
So when it comes to what rights consumers have, let's look at it from 2 perspectives, right? That's goods and that's services. So when it comes to goods, there's a couple of, as you can see on our graph, right? There's a couple of key provisos. One is, can a good be fixed, right? If it's broken or otherwise not functioning. If so, there's a number of obligations on the business that provided the consumer that good. Fix it, replace it, refund it. And in doing so, there's provisions in terms of like reasonable time and, like quality of like communication, that sort of stuff. Businesses are also liable for damages for foreseeable loss. But also there's a third category, and that's like if a good cannot be fixed or it's a failure of substantial character, there's an obligation to refund and replace, which is, 2 fairly straightforward concepts. When it comes to services, right? What are the obligations for business? Broadly, it falls into a couple of key categories, as you can also see on our diagram, right? The service, your obligation to remedy the failure within a reasonable time. If the supplier fails to do so, they can pay for it to be done at someone else's expense or cancel the contract. If the fault cannot be remedied, damages are possible. And I think broadly that sums up what happens when it comes to like dissatisfaction with both services and goods. Right, now let's turn to another key aspect of the Consumer Guarantees Act, right? And that is like, in what circumstances is it possible to contract your way out of the Consumer Guarantees Act? Right from the get-go, it's important to note that a business cannot contract out of its obligations to a consumer, but a business is capable of contracting out its obligations to another business, right? So that is a business-to-business transaction can be contracted out of. Now, this must fall under a couple of key categories. Both companies must, agree to it in writing. Both must be in trade, which means they're both you're buying for business purposes. And the terms must broadly be deemed by reasonable.
Finally, let's talk about the practical consequences of the CGA for business practices. As we have mentioned previously, only business-to-business transactions can contract out from the CGA. However, if a business attempts to contract out with a non-trade consumer, this results as a breach of Fair Trading Act. Penalty for the breach can be up to $200,000 for individuals and up to $600,000 for companies. Thank you for listening.